Now, but don't start planning to move back in with your parents just yet. There are other things you can do to delay or otherwise save your home or other property from foreclosure. However, once you receive the notice of sale, just don't sit there on the couch crying. Once the sale takes place, any effort you make to try and recover will be very difficult and very expensive. Even after the foreclosure company schedules a sale, in many cases the sale can be postponed. Sometimes it can be postponed just by calling and asking. In other cases, a foreclosure sale can be delayed if there's a short sale pending. Many people believe that a short sale will solve all their financial problems, preventing a foreclosure from going on their credit and eliminating all of their mortgage debt. But a short sale is not a miracle answer to your problem. A short sale is simply a sale of property for less than the balance owed on it. The mortgage lender agrees to release its interest in the title to the real estate for less than the balance owed so the property can be sold. And in return, the lender gets a cash payoff. A lender agrees to a short sale because in the current economy, they'd like to make some cash by selling the home you've worked so hard to keep. A first mortgage lender might agree to a short sale to keep down its losses. After all, if a property sits empty for months and months and is foreclosed on, the value can drop dramatically. But a short sale is not a win-win for everyone. You may believe the myth that a short sale is good for you because you're saving your credit and you've kept a nasty-looking foreclosure off your record. You may believe that a short sale goes through, your financial responsibilities have been satisfied. You may even be angry if you receive an offer for a short sale and your mortgage company fails to approve it. But if your home can't be sold in a short sale, instead of cursing, you may want to count your blessings because you've just dodged a bullet. In a short sale, the lender only releases the title to the property. You still owe the lender the balance on the original loan. There's the catch. Even if your property gets sold, your mortgage lender can usually still sue you for the balance you owe for up to 6 years. But if you lost the property in a foreclosure, your first mortgage company would only have 6 months to sue you, or they'd lose the right to come after you. Whether you realize it or not, the fact that you still owe for a portion of your mortgage balance damages your credit score even with a short sale. Doing a short sale is like having a voluntary repossession of your car, a distinction without any real difference. Down the road, you may receive notice from your lender saying that they're forgiving your debt. At that point, you might want to kick up your heels and buy the bar a round of drinks. Well, not so fast. You seem to have been fooled into thinking your lender has an actual heart. But by forgiving the debt, the lender has not engaged in an act of compassion or charity. Instead, the lender has taken a tax deduction and given you a horrible tax consequence. Not as nice as it sounds, is it? If you don't appreciate this nightmare right away, your bad luck will only get worse. And that's the kind of luck you don't want, especially in Nevada. If you forget to include this debt on your next tax return, the IRS computer will select you for a tax audit. The interest and penalties on the amount you owe as a result of an audit can easily double your tax debt. Now, if this sounds like a nightmare, you're not alone. Everyone facing this issue deals with this. You may want to blame someone, but blaming will not pay the IRS debt, which could be substantial. I know it's hard to believe that the IRS considers money you lost on the sale of your home is money that you earned. Boy, talk about kicking you when you're down. But isn't that the job of the IRS? Now, there are some exceptions to having to face tax consequences from a forgiveness of debt, but they don't apply to everyone. For more detailed information, check out the IRS website at irs.gov on the topic Forgiveness of Debt, or consult with your tax advisor. But wait, as the man on the infomercial said, there's more. It gets better, or maybe worse. You need to be aware of 2 additional problems when you lose property through foreclosure. First, if your mortgage company takes a loss from the sale, you can be sued for the balance you owe on a loan. Although this doesn't happen very often, your mortgage company can take its sweet time and wait up to 6 months to decide whether to sue you. If you have a second mortgage or home equity loan, you'll still owe that money as well, and the lender can sue you for that amount of the entire loan balance. Your second mortgage company can take as long as 6 years to sue you to collect this money. So if you can't afford to pay these large debts, you may have to reluctantly consider whether to file bankruptcy. By filing bankruptcy before your mortgage company forgives the debt, you can avoid having to pay income taxes on the money you've lost due to the rules involved with forgiveness of debt. I bet you never thought the word bankruptcy would sound so good. In fact, there are several reasons why bankruptcy can be a better alternative than selling the property through a short sale. If you'd like more information about whether bankruptcy is right for you, call my office to schedule a personal no-obligation consultation or for a referral to a bankruptcy attorney in your area. If you aren't able to delay the sale of your home, you may still be able to stay in the property a little while longer. How? Well, whoever bought your home at the foreclosure sale has to evict you. Although it's a scary process, if you're a fighter, this fight separates the grown-ups from the little kids. The eviction process begins when a document called a 48-hour notice is delivered to your door. Unless this document says to file paperwork, you can safely ignore it for a while. A couple of days later, a document called an unlawful detainer may appear on your door. Now it's time to put on your armor and go into battle. The unlawful detainer form should say that you have the right to challenge the eviction in court. At the hearing, explain to the judge that you have been through foreclosure and that you need time to move. You really don't need to say much more than that because the judge will probably give you an additional 30 days to find a place to live and move out. There are so many people in the same situation, this has become court policy. Just don't annoy the judge by being rude or acting like a whiny child, or the judge could refuse to help you out at all. Ask nicely and you'll be rewarded. So what have we learned? That lenders don't have hearts and that the IRS will find a way to get its money? But you already knew that. My point is that the foreclosure process in Nevada is complicated and time-consuming, but it's not the end of the world. If you can't realistically keep your property, and if it doesn't make financial sense to do so, you can use the process to delay a foreclosure sale and stay in your home rent-free for a considerable period of time. All of us property owners in Nevada have lost a lot of money on our real estate. Frankly, there's nothing any of us can do to improve the Nevada economy, but we do need to look out for our families first and get some peace of mind. I'm attorney Dorothy Bunce of the Fresh Start Law Offices in Las Vegas, Nevada. I hope I've answered your questions about foreclosure so that you can achieve the results you need and deserve.